For more, I should say, I'm joined now by Carol Lamb, a former U.S. attorney and a former judge. She's now an NBC News legal analyst. So, Carol, do you think that Mark Meadows made a legitimate case yesterday for moving his trial to federal court?
Well, Ryan, I think the reason you see the judge in federal court taking his time to make this decision is because it is not a slam dunk for either side. This issue doesn't actually arise that often. It arises more frequently in civil cases between the state and the federal court system. It doesn't arise that much in criminal cases. And in criminal cases, there is additional deference that's paid by the federal courts to state court prosecutions. So the facts here are such that Mr. Meadows is saying that, oh, everything I did was within my job scope as a federal employee. Fani Willis is, of course, taking the opposite view, and she put on members of the Georgia state government to say, no, he was way outside the bounds. He was acting as a campaign official, and he was interfering with our state electoral system. The thing is that Mr. Meadows only has to meet a fairly low bar. He just has to be able to make a colorable claim or a colorable defense. And what that means is basically a plausible defense. It doesn't require that he prove beyond a reasonable doubt that he was acting within the scope of his federal duties. So the judge is going to take the time necessary to put out an opinion that he thinks is going to withstand appeal. But that is the point, I think. The point is that either side, I believe, can appeal immediately this decision, and that is going to slow the proceedings down even more.
If Meadows is successful, how much of an advantage would it give him?
It really depends. And I think the reason you're seeing some defendants bring this motion to remove to federal court and some staying in state court is that there's some pros and cons to either position. I think Mark Meadows and his attorneys probably feel more comfortable in federal court. There's sort of one set of rules that applies to all federal courts, whereas Georgia state law has some unique attributes, as do any of the other 49 states. I think that they may be counting on perhaps a broader jury pool in federal court. There are some counties that they would draw additional jurors from, not just Fulton County. And the thinking is that there's some counties up there in northern Georgia that are a little bit more conservative than Fulton County. But one advantage he will not get, and I think there's some confusion about this, some people think, oh, if he goes to federal court, then if President Trump is reelected, he can then pardon Mr. Meadows. But no, even if this case moves to federal court, it will be tried on the Georgia allegations, not federal offenses. So there is no presidential pardon power over a conviction in federal court on Georgia. Crimes.
Right. It's essentially just changing the playing field. Everything else remains the same. So you have actually questioned whether or not it's a good idea to try this case in Georgia as a RICO case. What are your concerns in that regard?
It's not so much concerns. I think that Fani Willis is well within her rights to bring a RICO case in Georgia. I just think that folks should understand that Jack Smith's case against the former president in federal court is just as broad and has pretty much the same advantages that the RICO statute in Georgia has in terms of a broad conspiracy. Both Jack Smith and Fani Willis have alleged a very broad scheme, and that includes acts in Wisconsin and Pennsylvania and Arizona. And they can do that under both conspiracy law and RICO law. The one thing that RICO law in Georgia does give Fani Willis is a presumptive 5-year minimum mandatory sentence. But even there's another Georgia law that would allow a state judge to make part or all of that sentence probationary. So I think that both cases are legitimate, but they're both as broad as each other. The big complication in Fani Willis's case is the number of defendants, and we can see that has slowed the proceedings considerably.
And do you think it's realistic that the election conspiracy trial could begin and end before the Republican National Convention in July? Is that feasible?
Are you talking about Fani Willis's or Jack Smith's trial?
The federal, the special counsel one.
Yeah, so, things have actually started to sort themselves out. And I think that everyone is sort of acknowledging that Jack Smith's election fraud case is taking primacy for a couple of reasons. One is, of course, the importance of the subject matter, election interference in our federal elections. But the other reason is because it can be done very efficiently, even though it's a broad case in terms of subject matter. There's only one defendant. It's Donald Trump.
Right.
And that, as you can see, makes things a lot more efficient. Only one set of motions,
right.
Only one set of cross-examinations. And so I do think that there is a possibility that this could be accomplished before the election.
Okay, Carol Lamb, thank you so much for being here. We appreciate it.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.